California task force to study and develop reparation proposals for African Americans. Content warning. It contains discussions of racial discrimination, sexual assault, torture, lynching, and other forms of extreme violence. Contains unedited historical quotations and photographs of white supremacist hatred, torture, lynching, autopsy, and other forms of graphic violence.
Enslavement. Slavery era of American history. Federal and state governments empowered and protected white enslavers in their destruction of black family structures by treating enslaved people as chattel, unworthy of family love, care, and support. Transatlantic slave trade and reproductive slavery. Eric Douglas observed over 250 years ago, genealogical trees do not flourish among slaves. The vast majority of the nearly 400,000 enslaved persons brought over from Africa were children or young adults, and more than a quarter were children. Upon the arrival of enslaved people in the United States, private parties and state governments maintained no records of their origins, replacing their names with those of their new enslavers, names by which they were called throughout their lives. This erased an individual's identity, severed them from their family, and made it extremely difficult for them to find each other after emancipation. Chapter 2, Enslavement, for more detailed information about this process. Federal and state governments passed laws that protected enslavers' ability to destroy black families and use black women and their children as a way to increase the wealth of enslavers. 1662. English law governing the American colonies held that children of enslaved fathers were enslaved, but the child of enslaved women and white male enslavers were free persons upon their birth, thereby entitling them to the full protection of the law. Changed in 1662, when the colonial government of Virginia passed a law stating that all children who enslaved mothers were enslaved themselves, regardless of whether or not the father was white, black, enslaved, or free. Law created a new source of wealth as enslavers used these children to settle debts, pass on a larger inheritance, or otherwise enrich themselves. The doctrine underlying this law became known as partus sequitur ventrum, Latin for, that which is brought forth follows the womb. It was adopted in laws by virtually all other states in which enslavement was legal. The United States outlawed trafficking enslaved people into the country in 1807. The only legal way to increase the number of enslaved people and free labor for the American economy was therefore through domestic birth of new enslaved persons. Did a financial incentive for impregnating black women and girls and carrying the pregnancies to term. 16 historians have found evidence that enslavers raped black women and forced them to birth children to create more enslaved people and further enrich their enslavers. Professor Dana Ramey Berry has argued that this sexual slavery served to provide great benefits to both government and private actors within both the southern and northern states. The labor of black enslaved people created wealth for their enslavers, sustained cotton production and other private industries, and paid state and local taxes across the country. In the North, maritime industry, merchants, textile manufacturers, and even consumers of cheap cloth were all dependent on the southern cotton plantation economy, which was based on the sexual slavery of black women and men 20 and the destruction of black families. 21 Professor Berry argues that enslavers focused on the fertility of young black women during slave auctions, and that early childbirth was considered to be a valuable skill, like housekeeping and clothes mending. 2 Enslavers considered the birth of enslaved infants not with humanity, but appraised them with a monetary value, one that typically increased as they aged. 23. Enslavers and state governments maintained no records of the origins of enslaved Africans, and replaced their names with those of their new enslavers. Their identity severed them from their family, and made it extremely difficult for them to find each other after emancipation. 270. Pathologizing black families. Marriage between enslaved people. American governments prohibited or did not recognize marriage between enslaved people. Southern enslaving states, enslaved persons were generally prohibited by law from entering any legally binding marriage. Abolitionist William Goodell described the way that American law treated the families of enslaved people in 1853 as, "The slave has no rights. Of course he, or she, cannot have the rights of a husband, a wife. As a chattel, and chattels do not marry. The slave is not ranked among sentient beings, but among things, and things are not married." 25 Tennessee was the only enslaving state that allowed for marriage between enslaved persons, but the law consent of the enslavers for the marriage to be valid. Because enslaved persons were not considered to be human beings under the law, they could not enter into legal contracts. 27 Therefore, enslaved people could neither own nor transfer property, which is what American law recognized their husbands, wives, and children to be. 28. Carolina Supreme Court in 1858 said, the relation between slaves is essentially different from that of man and wife joined in lawful wedlock, because, with slaves it may be dissolved at the pleasure of either party, or by the sale of one or both, dependent upon the caprice or necessity of the owners. 29. Condition was compatible only with a form of concubinage, voluntary on the part of the slaves, and permissive on that of the master. 30. Statutes and legal mandates were not limited to the South. One notable example is the case of Basil Campbell, who at the time of his death in 1906 was one of the wealthiest black men in California. He arrived to California from Missouri in 1854 as an enslaved person, forcibly removed from his wife and 2 children, who never saw him again. After his death, his 2 adult sons from his marriage in Missouri sued to seek their inheritance, leading 3 different courts, including the California Supreme Court, to reject their claims. Indeed, one appellate court held, nearly 50 years after the legal emancipation of enslaved African Americans, that describing Campbell's marriage to his enslaved wife as a marriage would make a mockery of the institution. 34. Marriage. Interracial marriage, known as anti-miscegenation laws, devalued black families. Known anti-miscegenation law, passed in 1661 in the colony of Maryland, stated that a white woman who married a black man became an enslaved person. 35 other colonies followed suit to prohibit interracial marriage during slavery. However, from slavery through the era of legal segregation, American society accepted white men having sex with black women, whether consensual or rape, especially when those women were treated as the property of white men. 7. The children of these interracial interactions were typically enslaved and could not inherit their white father's wealth. 38. Fears of interracial marriage often led to violence. 1834, a false rumor that abolitionist ministers had married an interracial couple led to 11 days of racial terror in New York City. 9 mobs attacked a mixed-race gathering of the American Anti-Slavery Society and destroyed black churches, homes, schools, and businesses, as well as the homes and churches of leading abolitionists. 40. A similar incident occurred in Philadelphia in 1838. Punishments for interracial marriage varied by state, but in many states prior to the Civil War, white Americans were punished more often than African Americans, at least within the legal system. 32 scholars have argued that this reflects anti-black racist attitudes that, depending on the circumstance, black people were sometimes considered too irresponsible and too inferior to punish, and it was whites' responsibility to protect the purity of their own bloodlines. 3 punishments for African Americans, however, were still severe, including whippings, fines, exile, or even enslavement if they were free at the time of their violation of the law. 4. Although it is unclear how often anti-miscegenation laws were enforced, evidence suggests that they were used to make examples of high-visibility interracial couples, who were considered a threat to public order. 5. North Carolina Supreme Court in 1858 said, the relation between slaves is essentially different from that of man and wife joined in lawful wedlock, because, with slaves it may be dissolved at the pleasure of either party, by the sale of one or both, dependent upon the caprice or necessity of the owners. 271. Chapter 8. Recognizing black families. Parent-child relationships. Enslavement treated enslaved African Americans as replaceable property, so enslavers separated children from their parents if it was profitable to do so, and sometimes in order to discourage potential rebellion. This was justified by the enslavers in various ways. For example, Thomas R. Cobb, a legal scholar who drafted parts of the Georgia Legal Code of 1861-46, claimed that the black mother suffers little when her children are stolen from her, since she lacked maternal feelings. 7. Cobb helped write principles of white supremacy into Georgia law, including a provision that presumed African Americans were enslaved unless proven otherwise. 48. Their birth, enslaved children were considered property of the enslaver, and therefore enslavers controlled a child's life and upbringing. And from the time of birth, enslavers stripped away parental rights, often not allowing the birth parents to choose the newborn's name. Very soon after giving birth, enslaved mothers were expected to return to work and leave their children with extended family members or an older enslaved woman who was assigned the role to watch over children on the plantation. Even if an enslaved parent had some control over their child's life, the enslaver held the highest authority and could make final decisions as to who would take care of the child, what activities they participated in, whether they would be separated from their family by selling the parent or child to a different enslaver. II. As a result of many children and parents being separated through chattel sales, orphan children were often adopted and cared for by friends, extended family, or the enslaved community as a whole. 3. This approach of allowing white strangers, aided by laws and government actors, to take a black child from their family. After enslavement via the apprenticeship system and by the modern foster care system, as discussed further below. Children typically received no formal education and were expected to work as soon as they were physically able, forced to work in the fields as young as 8. Where they often worked in a similar capacity as the adults, working fields, tending animals, cleaning and serving in their enslavers' houses, and taking care of younger children. 5. State law legally entitled enslavers to separate enslaved parents and children at any time, and to relocate them at different plantations at the time of the child's birth. 6. In some southern states, approximately 1/3 of enslaved children were separated from one or both parents. 57. An enslaved woman forced to separate from her family at age 7, related that she used to say, "I wish I'd died when I was little." Members of a family could be separately sold as enslavers fell into debt or wanted to raise profits. 59. In some parts of the South, a black enslaved person had a 30% chance of being sold in his or her lifetime. A quarter of trades of enslaved persons across state lines destroyed a first marriage, while approximately half destroyed a nuclear family by separating immediate family members. 1. Opponents of slavery, including those in the federal government, recognized how it destroyed the families of African Americans. Advocating for the elimination of slavery, U.S. Senator James Harlan of Iowa stated that slavery effected the abolition practically of the parental relation, robbing the offspring of the care and attention of his parents. Scholars argue that the anguish caused by the threat of family separation coerced enslaved people into working without complaint. 3. The horrors of family separation during slavery were highlighted by abolitionists as a central strategy to enlist people to their cause. 4. Near the end of the slavery era, in the 1850s, some southern states responded to public horror at child separation by passing laws prohibiting the taking of infants from their enslaved mothers. 5. Modern scholars analyzing this development have argued that these laws were not passed out of concern for African Americans, but to assuage public outrage in order to maintain slavery. 6. Family kinship structures. In order to cope with the destruction of their nuclear family, enslaved people created deep, extended supportive relationships with other enslaved people. 7. Some historians have argued that the extended kinship structures of black enslaved people mirrored similar structures in their native West African homelands. 8. The role of black grandparents, other extended relatives, and older black caregivers who were not biologically related took on particular importance. 9. With black grandmothers often serving as a central figure within a plantation, ensuring the care of all children of enslaved parents who were sold to other enslavers, killed, or otherwise removed from their nuclear families. The reliance of black mothers and African Americans on extended kinship networks was a necessity for mere survival, beginning in the slavery era and continued through legal segregation and other forms of discrimination. 21. Early black historians argued that the legacy of slavery created disorganization and instability in black for generations. 72. In 1899 and again in 1909, prominent sociologist and social critic W.E.B. published detailed, fact-driven analyses of black families, demonstrating the many ways in which a lack of economic means and opportunities after the end of slavery harmed black families in both the North and South. 3. In 1932, sociologist E. Franklin Frazier argued that black families had particular difficulty adapting to the drastic changes of the early 20th century due to the way that enslavement destroyed black families and traditions. 4. As discussed further below, these resulting harms have been used throughout American history to claim that the black family itself was to blame because it was dysfunctional by its nature.